Well, we'll get started here. As you can see, we're going to go through this PowerPoint on amendment of governing documents. I'm going to stop sharing the screen for just a second. So I'm Ed Ronsman, partner with McCabe and Ronsman here. Jim Roach, one of our partners in our firm. So we wanted to offer this webinar for you all on amending your governing documents. I know that some businesses kind of come to, I don't want to say a standstill, but there's some normal operations are going on right now. We understand that, and especially from a membership meeting or an annual meeting standpoint where you would have a member meeting and vote. And so we've worked with a lot of communities that are interested in amending their governing documents, and we thought this would be a good opportunity to kind of take a look at what do you have in your governing documents right now, what are some things that we would recommend that you take a look at from an amendment standpoint. We'll go through some key provisions for you and kind of walk you through the process for it. It is going to be document specific for a lot of these things we're talking about, but we want to give you some ideas. A little bit about this, if you've joined us before, we've been utilizing Zoom, and for this, you can see that there's a Q&A button that you can ask questions. That would be the way that we would request if you have a question from us, is to type it in and it will pop up for us there. There is a chat function, but it's harder for us to kind of go through and make sure that we're addressing each of the questions that are asked. So please feel free to type in a question to us. It will pop up. If we can answer it during it, we will, but most likely we may hold a lot of the questions to the end once we get through the materials for you. So we are also recording this. If you guys see it, we'll be putting this on our YouTube channel. Please feel free to subscribe. If you go to our website, it's flcalegal.com. On the top right corner, you'll see a little YouTube link. And you can go there, and we have a couple of videos, one from a board certification event, another one is from a COVID-19 webinar, and we'll be sure to post this there as well, and we'll make that available within the next day or two. So with that being said, I'm going to share this. We're going to get started on our PowerPoint on amendment of governing documents. All right, so what we're going to be talking about first is we want to talk about your governing documents, an overview and the priority. We're going to go through the tiers of these. If you've been to our board certification class, you've heard some of this before, but I think it's a good refresher when you're talking about amending to say which document controls, which has the higher priority. We're going to dive into some of the key provisions that we look at from an amendment standpoint, collections, enforcement, finding and enforcement, elections, and some other provisions that we can talk about. Then we go into statutes versus the governing documents, what controls, and in typical lawyer fashion, what we're going to say is it depends. It just depends on the provision. We'll get to that in a little bit. And then finally, we'll end up with, all right, so you've gone through, you've identified certain documents that you want to amend, some practical tips and considerations that we've seen as attorneys. I'm sure if our managers are on here that you've seen some other things as well. Please feel free to mention that either in the Q&A or in the chat side for any perspectives that you may have. But we want to walk you through some of that because there is some politicking that goes on if you do have some changes that you want to make and the best way to do it. So going over the documents, your highest priority document is your declaration. That can be your declaration of condominium or your declaration of covenants and restrictions, your CC&Rs. It's called different things, but basically it's your declaration that contains pretty much your use restrictions. What are you allowed to do with your property? That's pretty much what's contained in your declaration. Your articles of incorporation are your next priority document. That is the document that's recorded. It's actually filed with the state. If you're an association that was incorporated in 95 or more recently, you should be able to go to sunbiz.org, type in the name of your association, and your articles of incorporation are there, including any changes to your articles also have to be filed with the state, and then you can also see your annual filings. Your articles of incorporation set up your association as a corporation. Probably almost all of you on this call, on this webinar, are a corporation, not-for-profit, but you are filed with the state. Then you have your bylaws. Your bylaws, sometimes if you're newer to an association, you know, all of your governing documents are sometimes referred to as bylaws, but it's actually a specific document that more relates to procedural aspects, you know, composition of the board, how are meetings held, some of the notice requirements. It's more of a procedural document than it is telling you what you can or cannot do with your property. And then you go into your rules and regulations, and then I have in there also your guidelines. Rules and regulations typically kind of match up with your declaration. Your declaration may say They may have certain use restrictions, but it'll say subject to rules promulgated by the board. And then that's typically the way that rules are passed. It's by board vote. We have seen some communities where, for whatever reason, when they were originally drafted, they had rules and regulations, but it said it required membership approval. It would be document specific, but probably 95% of the time we see that the board is able to adopt new rules. And then we also have in here architectural guidelines. I put those in the same categories as rules and regulations because they're typically, the ability to adopt those typically flows from your declaration or another higher priority governing document. And it's typically done by vote of the board as opposed to a membership change to change your governing documents. I'm sorry, your architectural guidelines. So going into the declaration, you want to review your declaration to determine the procedure for amendment. The default is 2/3 approval of the entire membership unless it's otherwise provided in the declaration. Now, I would say almost in every instance that we've seen, there is an amendment provision in your declaration already. So there's not a provision in the statute that says that you must have at least X percentage of owners vote in favor of it, unless there's very limited instances. And it's really for both condos and HOAs. It deals with if you're changing the share in the common elements, if you're trying to say instead of having a 1/40th share, you're going to a 1/20th share, but other people are saying the same, that changes the math. That does require extraordinary approval, basically all of the affected owners. Or if you're changing anything regarding priority of liens or mortgages, that typically requires the mortgagee approval. But for the most part, and there may be a couple other limited instances that the statute says that you have to have certain approval requirements. For the most part, it's going to defer to what your documents provide. So while it says 2/3 is the default, typically your documents will have a provision for it. Then the third bullet point that I think it's really important to note when we're talking about amendments and which documents should be amended is that provisions in the declaration of condominium or your declaration of covenants and restrictions are, quote, clothed with the strong presumption of validity. That comes from an appellate case. And it basically talks about if it's in your declaration, it typically means that it was either adopted by the developer initially and recorded, or it was voted on by the membership. Maybe you don't have to have a membership vote to amend your declaration, but probably all of your document changes require membership approval. So once you approve that, it's provided in your declaration and it's recorded, courts have found that it's clothed with a strong presumption of validity, as opposed to, we'll talk about the standard maybe for a rule, and if you're challenging a rule, and that's based more on a reasonableness standard versus this, it's difficult to overturn a declaration amendment that's been properly approved or voted on or was put in place by the developer, for example. Your articles of incorporation, your bylaws for HOA, the default is that all governing documents may be amended by 2/3 of the voting interests. I had to take a look at the Condo Act and the HOA Act, and it mentions just governing documents specifically, I guess in broad terms, I should say, as 2/3 of the voting interests. For condos, there's that provision that the bylaws, the default is that 2/3 of the voting interests are required for approval, but there wasn't a comparable provision for the articles. So then what we do is we look at the Corporation Not-for-Profit Act, which is Chapter 617, and that says in there that the default rule is that majority approval of the members in person or by proxy is needed to amend the articles. Now again, that's just the default rule in the statute. Your documents may have a more specific amendment requirement, and it's almost always the case that the bylaws and the articles contain an amendment provision. Jim, did you want to talk a little about maybe kind of looking at the bylaws and the articles and sometimes how they kind of mesh together?
Right. So your articles of incorporation establish the corporate entity that is your association, and it'll likely have things in there regarding the number of directors, qualifications for directors, whether they have to be a member of your association or not, and things like that. They're a little bit broader, or typically they're a little bit broader than the bylaws, and the bylaws are typically nuts and bolts. But one reason you have to look at them for consistency purposes is, let's say you want to change the number of directors on your board of directors. Well, if sometimes your articles will say your board shall be governed by a number of directors between 3 and 7 or 3 and 9 and shall always be an odd number. And then your bylaws will say the board of directors shall be 5 directors, right? Well, that's fine. That fits within your articles, and you can move anywhere within those boundaries that your articles outline or provide for. But where you might have some difficulties are, if your articles say establish a specific number and your bylaws establish a specific number of directors, then in order to change that, you'll have to comply with both amendment provisions of both documents in order to change the number of directors. So it's important to be mindful and look at both documents when you're looking at making changes to your association or your board composition.
Jim, I think this is a good time, Jim. We had a question here. What about the plat in terms of the priority there with the plat document, and how does that impact anything that might be on the plat with the rest of the community?
So yeah, that's a good question. The plat is important, and oftentimes you'll have, especially in an HOA context, you'll have the declaration refer to the plat and incorporate the plat. Typically, you shouldn't have too much meat in your plat, meaning there shouldn't be a whole lot of use restrictions and things that you should have to check often. But it will have things like the total number of lots, which might set your denominator in terms of allocating assessments among the membership. You'll also have some things like dedications of easements or dedications of property for public use and things like that. You shouldn't have to refer to them too often, but they are in the nature of encumbrances or covenants and restrictions affecting real property. It's recorded in the public records the same way your declaration is. So I would say that it's kind of up there along with the declaration, except that you probably don't need to use it all that much. I mean, again, you'll have some easements, you'll have the number of lots in there, so it's important to be conscious of it. But you know, it's rare where you'll actually have to go to court to enforce something that's in your plat as opposed to in the CC&Rs or your declaration.
Yep.
But it's up there pretty high. Is a bottom line to that question.
All right, so going into rules and regulations and your architectural guidelines. So you want to check for authority to adopt rules and regulations regarding your unit or the parcel use, if you're a unit for a condo, parcel use for an HOA, and for common area use. I bring this up because you have to have authority in a higher priority document to basically establish these rules. And it's pretty much in most of the governing documents that we've worked with. We have seen limited instances, though, where it says that the board is able to promulgate rules regarding common area use, but it doesn't say anything about using the unit or the parcel, and which means then that if you have use restrictions already regarding the unit or the parcel, you would need to amend that declaration, for example, rather than maybe being able to adopt a rule. So again, in most documents, you have the ability to do it, but it actually does require some analysis to see, do I have the ability to pass a rule not only as to the common areas, but for what somebody can do with their unit? And that can be from pet restrictions, what you can do with your balconies, storage, from an appearance standpoint, can you have a basketball hoop on your property, that sort of thing. You need to double check that just to make sure that you're able to adopt rules not only for the common areas, but for the actual parcel. If you do adopt a rule regarding parcel use, there is a specific, even if it's done by board vote, there is a specific notice requirement. Normally you have 48 hours notice for a board meeting, but for anything regarding unit or parcel use, it requires 14 days written notice to be sent out to the membership before you can adopt that rule. We worked with one community, I think we might have a couple people on the call, but it was an interesting one of, they had people that were putting up bounce houses that you can rent for parties, and they were putting it on their front yards, and they passed a rule stating that, hey, that's something that we're going to allow, but you have to go through these steps. You can do it within these hours. We advised them that you need to pass, that actually requires 14 days notice because you're passing a rule regarding what somebody can do with their property. And so to have that specific rule in place, you might have to have a little bit more notice than what you normally would for a board meeting. So typically the board may amend it. Again, we want to review the authority to adopt and amend architectural guidelines. And so this is more probably for our HOA members and our managers in here that work with HOAs than it is for condos. You can have architectural guidelines for condos, but for the most part, it's for HOAs where it's somebody that, what can I do with repainting my house, replacing my roof, some of the more exterior home and landscaping requirements that are going to be found in your architectural guidelines for HOA. You want to make sure that you have the authority to adopt or amend your guidelines that you maybe have been doing. And so what I find and what I've recommended to clients is to have some authority and look in your documents to make sure the declaration might say there's an architectural review board and they're able to promulgate rules from time to time, or the board promulgates those architectural guidelines, but that you're not necessarily putting all of those architectural restrictions in your governing document, like your declaration itself. Because you can see what the problem might be is if you start getting too specific and you say, well, you're only allowed to use this one type of grass or these 3 paint colors, and your community changes or the nature of your community changes in the future, you would have to have probably membership approval to change that, as opposed to having some language in your declaration that says that we have architectural guidelines that can be amended from time to time, and then that can be done though by board vote, so that you can have a board vote to maybe change and tweak them from time to time without actually having to have a membership vote. The other thing too is when you're looking at your architectural guidelines, you want to make sure that there's a fine line between being specific enough that we can have something that you can enforce if there is an application you can point to why it doesn't fall within your criteria and why you're denying it, versus being too specific that you've kind of cornered yourself into something that, like I said, even if you put in your guidelines that you have these 3 types of paints, on the one hand, that's great. It's pretty easy to provide that to the owner and say you need to match these. But what if that owner comes back and says that type of paint is no longer allowed, or they don't make that anymore, but I have something here that's very specific? You might want to approve it, but it might be contrary to what your guidelines provide because you're very specific as to the paint requirement. So you might say something along the lines of, you have to apply and demonstrate, the exterior paint color that's going to be used, and the architectural review board has the ability to approve or deny based upon the aesthetics of the community. Some type of language where you're not being too specific that you're backing yourself into a specific brand or something, but still able to make decisions on it. I don't want to say case by case, but still each home is going to be a little bit different than the other one. And that as long as it's within the aesthetics of the community, that there's some deference that's provided to the board. Jim, what do you think about anything else from the architectural standpoint?
Yeah, it's trying to balance that line of not handcuffing yourself and approving something that's otherwise compatible and harmonious with the rest of the development and adjacent improvements, but also not making it so mushy such that someone can challenge your decisions because there are no objective standards by which they're measured or reviewed. So you want to have some sort of objective criteria in your architectural review guidelines. So, if you're challenged, it's not easy for someone to say, well, your decisions are arbitrary and capricious because you're just kind of sitting there and, shooting from the hip and whether you want to approve them or not. You have no guidelines or objective standards that you're comparing what people are applying things against, right? So it's not handcuffing yourself while also still having some objective criteria.
Yeah. So I think I'm going to take just a couple questions here because there's some good questions that are related to this. Pat asked, how do you handle conflicting paragraphs within the same document? So within the same document becomes difficult. You're going to have to, sometimes the courts will look at the document as a whole versus the specific provision usually will control, but sometimes the courts will look past that if there's conflicting provisions, say, what's the intent? You might be able to pull from other provisions in the documents that may lean towards one interpretation over the other. That's obviously probably a result of bad drafting, which would require amendment in the future, but that's typically how courts will handle that. If you have conflicting paragraphs within different documents, it's the higher priority document that's going to control. Sometimes what we found, and I know that wasn't the specific question from Pat, but we do get that question where you might be a board that takes over and you look at your documents, your declaration, your bylaws, and your articles, and there was an amendment to the bylaws, which was done by board vote, but then you realize that really amended a provision of your declaration. Even though the two might talk about similar things, the board may have tried to pass an amendment by a board vote as a bylaw change that really should have been voted on by the membership. And that can be where we would look at that. If you're working with your attorney from an enforcement standpoint, we would look, the thing we always look at as an attorney is to say, okay, you have a violation and you want us to send a further letter. What is the violation itself? And you would point us to your governing documents. And that's where we would look at that to say, okay, it looks like there's a conflict here and you might be relying upon a board vote that may have actually required membership approval. Let's talk about the enforceability of that. And that's something that's come up before. The other thing that comes up is, especially if it's a rule, we've had instances where we've been asked to send violation letters to owners and they've wrapped up fines. And it comes out to be, I say, okay, well, what are the fines based on? Well, they're not taking care of their property and we need them to pressure wash their house every so often. And I'll say, well, they may have been relying on a provision in their documents that says you need to keep your property in a neat and clean condition. That's a pretty broad provision that reasonable minds may differ as to what is neat and clean. And so if you really want people to pressure wash their driveways every year, for example, that should be done by a board vote. And we can talk about the reasonableness of that. It's judged under reasonableness standard, but at least it's done by board vote. Provide 14 days notice because it's regarding what somebody has to do with their property. And then at least it's a specific rule that you're enforcing rather than, we see that a lot. And so if you're finding that you as an association are trying to, or if you have violations that are based on a pretty broad neat and clean condition standard, it might be where you want to pass rules interpreting that specifically. How long can the grass grow before you consider it to be a violation? Pulling the weeds, that might be a specific thing. We need to talk about those specific things that might be more suitable as a rule so that you can specifically identify that from an enforcement standpoint. Otherwise, you come down to, I don't know that this is actually a violation that we can enforce, because I don't know that you have been specific enough that we're worried that a court or a jury may have a hard time saying that this is an actual violation of your declaration. Patrick asked, our covenant says that our architectural review committee has 3 members. Do we have to have a member vote to change the number, for example, for a range of 3 to 7, or can that be decided by a board vote? If your declaration, and Jim, I'll let you weigh in, but I think if your declaration says that it's 3 members and it's pretty concrete on that, I would think you would need to amend your declaration to change that. But if it has a range there, then that can be done by board vote.
Right. I think you have to go through whatever procedures are in the document establishing the architectural committee at 3. So if that's in your declaration, and your declaration requires membership approval to amend, then I think, I guess unfortunately you'd have to amend that declaration provision to give yourself some more flexibility in establishing the number of committee members.
So Brent asked, I think going back to the condo default language, that's the 2/3 for everything except for the articles. The articles, the default language, it's majority approval at a meeting where a quorum is met, because it said for majority approval for members appearing in person or by proxy. But for everything else, when we talk about 2/3, that's of the entire membership, not just at a meeting where a quorum is met. Now, if your document provides for, and we see a lot of documents that say it's 2/3 or it's 3/4 approval at a meeting where a quorum is met, then of course your quorum is really an important number there, because you need to make, whether it's 30% for HOAs or majority for the condo, as long as you make that, then it can be based upon a certain percentage of those appearing in person or by proxy, as opposed to the entire membership. So it is very document specific.
And when we help clients draft amendment provisions, amendment to the amendment provisions, we like tying votes to the quorum, because those are people who are actually participating. If your votes are tied to a percentage of your entire membership, then anyone who doesn't participate is an effective no vote. So we like tying things to the quorum, because it's based on the decisions of people who are participating in the process.
Chuck asked a question here. We had a couple questions from George that we're going to address later regarding elections and rental, but there's a question about the documents override the other declaration, or if there's a CDD. For those of you that don't know, a CDD is a community development district. I refer to it as kind of a quasi-governmental HOA. It just depends on what was recorded as part of the approval, or how that CDD was set up, and what's recorded as a restriction in place. Typically, though, what I found is that the CDD will be set up, and that will control if there's a conflicting provision over the declaration. But for the most part, there's good, kind of harmony between the CDD is going to control these areas versus the declaration controls these areas that might be owned by the association versus CDD property.
There shouldn't be a whole lot of overlap.
Yeah. Chuck asked, is there a way to get around the 2/3 votes? Is it possible to get that from 959 homeowners? Completely understand. It really regards some politicking, if that's what the threshold is for your community. And then it just requires you to get especially creative as to what can we pass as a rule that might be a lesser threshold that would still be in harmony with our documents, that gets us to what we're trying to do as a community. But that typically is the case for larger HOAs, especially like master associations, or just large single-family residential HOAs that have a hard time getting that approval. It's there's a lot of door-to-door going along. We'll talk a little bit later about practical considerations, but it does maybe result in trying to have the meeting and then adjourning it to a later date to consider it and go out and get more proxies. We'll talk about that a little bit later. And we'll talk about finding committees a little bit later. So I'm going to jump along to our next, where we're on the slide here. All right, so some key provisions. Collection of assessments. I'm going to turn it over to Jim in just a second here, but really, when we're talking about collection of assessments, right now we're in a state where a lot of owners have been paying their dues. If any of you have been on your board, or for managers that have been managing your communities for 10 years or more, we're not at a point where we were 10, 11, 12 years ago with so many owners that weren't paying their assessments. I think there you had the housing boom, and you had a lot of investors that were applying and taking properties that they just could not afford and walked away from them. We haven't seen that as much right now from an investor standpoint. You're going to see it more from homeowners that have lost their jobs and are trying to make decisions now on what bills am I going to pay. And I think we're going to have a lot of collection issues that come out of it. But I think it might be a little bit different if I can kind of, my projection might be you might have a lot more owners that are delinquent, but that are going to try to work with your community than maybe what we saw in the housing crisis 10 years ago, because we saw so many instances there of people, hey, this is a bad investment, I'm walking away, I'm not touching this, as opposed to homeowners that are trying to keep their property. But where this comes into, what we always recommend with our associations is, if you're amending another provision of your documents, look at your assessment collection provisions and your lien priority, because that really affects the responsibility of a future purchaser that takes title either through a foreclosure, a deed in lieu of foreclosure, or any other type of conveyance, where they may get, I don't want to say a free ride, but they might not have to pay what another owner might have to pay. So Jim, you want to talk a little about that, like with the third party and the safe harbor provisions?
Yes, and the reason we're bringing this up is, this is kind of related to our prior COVID presentation. It's just, we see that there could potentially be some issues with collection of assessments that are sort of part of the fallout of the COVID-19 situation. And what we're trying to get at is, we don't want your documents to impair you or negatively affect your ability to collect assessments and unpaid expenses from someone who might acquire the property through foreclosure, in the unfortunate event that it happens. So, let's say a mortgage holder forecloses, the property is sold at mortgage foreclosure sale, and either a third party purchases it, or of the mortgage foreclosure, the lender itself purchases the property. And there are statutes establishing what the association can collect from a purchaser foreclosing that acquires title at a foreclosure sale. And there's a statute that establishes it, but there's case law that has come out, post 2008, which basically stands for the proposition that, okay, the law provides for that liability, but if you and your governing documents, condo or homeowners association, provide that you can only collect a lesser amount, then we're going to hold you to your contract, notwithstanding what the statute otherwise allows for. So, in other words, your documents can set a lower ceiling than the statute otherwise would allow you to collect. And there's no other provision that you can look at in your governing documents that will have as much of a direct financial impact on your community as your assessment collection provisions. And what we're unfortunately seeing, and what we've seen in the past, post 2008, is, we have at least an argument to collect a certain amount from that purchaser foreclosure sale. But your documents include language that limits their liability beyond what we could otherwise collect. And we're getting people acquiring these properties, investors and lenders and so forth, that are becoming more sophisticated and are aware of some of this case law that's developed. So, as soon as we try to collect the full amount that's owed, they'll send us a letter, an email saying, here's this case saying, and here's your governing document saying you can't collect that from us. And it's unfortunate, because the only reason is you have a provision in your documents that we could otherwise remove if we addressed it on the front end. So this is trying to prepare you for what might happen as, some potential collection issues as they fall out from COVID-19. So generally speaking, when we say safe harbor, when a mortgage holder forecloses a mortgage and takes title to a property subject to a condominium or homeowners association, it's generally liable for the lesser of 12 months of common expenses and assessments that accrued prior to its acquisition, or 1% of the total mortgage amount, right? That's if it's the mortgagee itself. If it's a third party, like an investor that purchases it, generally they're joint and severally liable for all the unpaid assessments from the previous unit owners or homeowners. But again, if your documents say, and some do, particularly many homeowners associations, older homeowners association documents, they'll simply say that anyone who acquires title to property after foreclosure isn't liable for any pre-title assessments. And that's unfortunate, because A, the law allows you to collect more now, and B, that means everyone else in your community will be subsidizing those unpaid expenses associated with the fact that a mortgage holder foreclosed and took title of property in your community. So while you're under the hood, so to speak, it's like, why replace the battery if the alternator is also bad? If you're looking in your governing documents and you have something that you would otherwise need to amend, while you're under the hood, so to speak, take a look at your collection of assessment provisions. From our standpoint, we're so used to looking at these, it doesn't take a whole lot longer for us to look at it while we're already looking in your governing documents, and see if there's something you can amend as part of that to protect the financial interests of your community going forward, and particularly in situations where it's investors that might acquire properties or other lenders.
Yeah. And then the last point on that is really, I would say, definition of common expenses. I believe it's in the HO Act. There might be some argument that if you amend a common expense to include unpaid late fees, interest, and attorney's fees, or something to that effect, that you might be able to include that as part of the safe harbor amount. That's where we take a look at that. But what you're trying to do, and where it's an easy sell to your membership, is you're not telling them you're not allowed to do this with your property, or you're not allowed to rent. What a lot of amendments can sometimes be, it's changing what you're allowed to do with your property. For something like this, is we're just trying to protect against anybody else that purchases in the future. We just want them to pay what the statute requires them to pay at this time, and not have I wouldn't call it a free ride, but kind of a free ride because our documents were older and they have worse language for us as a community. And so that's where, if you sell it to your membership that way, they're like, well, this doesn't impact me in any way negatively, really. Why wouldn't I go for this? So that's one way I think we always want to take a look at that first, and especially now, as I think that we're going to go into a period where we're going to see more people delinquent, we're going to see more foreclosures. If you can amend this now, it at least gives us an argument, if you're working with us as your law firm, that we can use it against a subsequent third-party purchaser or a first mortgage holder that takes title in those circumstances where they might otherwise try to get out of it. And it's a way to maximize what we can get for you from a subsequent purchaser. All right, let's see. All right, so going into finding and enforcement, this is one where we get lots of questions about the enforcement process. The statute changed in 2015 to basically flip it, where it's the board that imposes the fine, but it's this committee that's made up of 3 or more non-board members that kind of says yes or no as to the fine and whether or not it should be collected. The statute is, for all that it has there, it's not very detailed as to the process, except to say board imposes the fine, but the fine cannot be collected until it's approved by the committee, and you have to give the owner at least, or the violating party, at least 14 days notice before that hearing is held before that non-board member committee. It doesn't say anything about when does the fine necessarily start. When can the board say that this fine is retroactive as to this date, or is it from the date of the board meeting going forward? It doesn't say how many notices you have to provide. And so we've seen in some documents that they were drafted in such a way to have a little bit more of a detailed process as to how the fining process should go. And that might be a little bit different from what the statute provides. So you want to compare what your documents provide for fining and enforcement versus what the statute allows. Especially, you talked about the daily fine amount. The statute says you can go up to $100 per day, not to exceed $1,000 in the aggregate. For HOAs, you can amend your documents to go above the $100 daily and above the $1,000 aggregate amount. But if you have a lower amount than those $100 and $1,000 amount in your documents, it's likely, almost certain, that the court is going to say that that's going to control. The statute just allows you to go up to it, but if your documents have a lower amount, that's what's going to control. So we've seen some communities that say that it's $5 a day. That's all you can fine. So it's going to take you 200 days to get to the $1,000 amount. So you might have to look, and you should look at your documents to see, do we need to tweak anything regarding our finding and enforcement process to kind of match what we're doing, or to match what maybe what's in the statutes right now. The other thing that for HOAs, so for condos, unfortunately, you can never lien for a fine as a condo association. That may change in the future if they amend the statute, but for the time being, it's pretty specific. For HOAs, it says that no fine less than $1,000 can become a lien against the parcel. So the way that we've interpreted that is that it at least opens the door that if you reach the $1,000 amount, that you can collect it kind of like the way that you collect an assessment. It at least opens the door that you can lien the property and then go through the foreclosure process potentially for it. It's just that the statute's not very specific. So what we've recommended, and really this is kind of aligning the fining portion along with maybe the assessment portion, and might have, they might reference each other, where you'd say any fine reaching $1,000 or more is treated in the same way as an unpaid assessment, for example. And that would make it easier for us to collect that fine that reaches that $1,000 amount to be able to go after an owner. But if it doesn't reach that $1,000 amount, you really can't treat it like an unpaid assessment. It's kind of a separate obligation that the owner owes to the association that you can pursue through mediation or arbitration if you're a condo or an HOA, or through a small claims action, for example, if maybe the violation's been corrected but the fine amount is still outstanding. So that's one thing to look at for HOAs as opposed to condos, that you might have a little more flexibility, and we recommend to add that language. It kind of gives us a better argument to lien them for it, and also gives you the argument at least to, if there's a closing and they request an estoppel as part of the closing process, that if they reach that $1,000 amount as an HOA, that it's easier for us to recommend, okay, I think it's okay to put this on the estoppel to have them pay it, because you can argue that the statute allows you to lien for it, which is what the estoppel is meant to cover, any outstanding obligations that could pass over to the new owner. I'm going to take a look here just to see if we have any questions that might impact us what we're talking about right now. Let's see. Can you amend to have finding committees consistent of one person? No, the finding committee needs to be at least 3 members that aren't that are members of your community that aren't on the board or that aren't officers, and they can't be. I believe it either says family members or spouses, one of the two.
Yeah,
This
spouses, brothers, and sisters. There's a
Yeah.
certain degree of consanguinity, but yes, they can't be related to the board.
Yeah. Brent asked, what document can you add higher fines to? Can the board do it as a community standard? So the statute actually says that for HOAs to go above the $100 a day and the $1,000 amount, I've looked at this and it says unless it's provided in the governing documents. It doesn't say that it has to be in the declaration or the bylaws. So could you presumably pass it as a rule because that might be done by way of a board vote? It's possible. I've always recommended trying to add it as a declaration provision because when we went back to, then if you start changing your fines as a rule, it might go into a reasonable standard. A court may find that $100 a day for not removing your trash bins and bringing them back inside, you could get into an issue where it's judged on a reasonable standard. I think you could do it, and the statute says governing documents, and the rules and regulations have been recently amended in the statute to be included as part of the governing documents. But we always try to recommend getting a member vote if you can to increase those fining amounts.
It's also going to depend on what fining provisions are in your existing governing documents. I've seen them parked in sometimes in the declaration, sometimes in the articles, not as much, and sometimes in the bylaws. So you still have to make sure all your documents are consistent.
Yeah. Chuck asked a question, says, after the appeals board gives their final judgment, can the homeowner ask the HOA board to override? You can, but I've always advised against that because what happens is that the board imposes the fine in the first place, then they send it over to this committee where it basically says, we've imposed this fine, you need to approve it. Here's the fining package that you would need in terms of the board decision, documentation from management, photos and stuff. And if the committee says, yes, we're going to approve it, if you allow that homeowner to go back to the board to override it, you're basically going back to the original entity that imposed the fine in the first place. And so by doing that, you can do it. There's nothing legally prohibiting. But I think from a practical standpoint, you might run into issues with your fining committee by saying, why did you guys send it to us in the first place? They might say that you were wasting their time by sending it to them if you allow it to go back to appeal because you're basically starting over with the entity that first noticed it. So I'd be careful about doing it. There's nothing prohibiting it. I just think from a practical standpoint, you might have a harder time with your fining committee if you're sending it to them and kind of overriding their decision that they made.
Yeah, unless maybe perhaps it's in exchange for the owner complying, right? Yeah. It's used as a tool to get the owner to comply with what you're trying to get them to comply with in the first place. Then I think it's probably okay.
Robin asks, instead of defining daily and aggregate amount in the documents, can a statement just be made that states fines are based on Florida statutes such that the documents will always match the Florida statutes? So it just depends on what language you have in your governing documents. If they're silent as to fining, we found, and there's appellate decisions that tend to support this, that you can use the fining statute. You don't have to amend your documents to allow for fining. And so then you would default to the maximum daily amount of $100 a day up to $1,000 in the aggregate. If you're going to do something different from that, that should at least be done by, I would say, a resolution at a board meeting. But really, you should amend a document to provide if you're going to have a fining schedule, or instead of having a different fine for each violation, you might have it based upon if it's a repeat violation, for example. But what you cannot do, and what we've advised against, is instead of the board meeting to impose the fine, saying, well, this is a violation, it's our standard that you're fined automatically this amount, so we're not going to have a board meeting and you're automatically going to this hearing. You need to have some method to either have the board approve it, which is what the most conservative way is, or some boards have delegated their fining authority to an individual, but there still needs to be a letter stating that a fine is imposed as of this date. And if you delegate that fining authority to one person, just note that there's a risk that an owner could challenge it by saying that this is a non-delegable duty that the board has to actually impose the fine. So sometimes we're asked, well, we have a policy that says that if you do this, then you're automatically fined. You do have to go through the process and have the board approve it, or have some delegation, from the board as to some entity, and it still has to go in front of that committee to say yes or no on the fine amount. I'm not sure if that's what Robin's question was, but I know that that's kind of a follow-up to it. James asked, can you raise the fines over $1,000? You can if you're an HOA, and it has to be a governing document change. For condos, you cannot go over $1,000 in the aggregate. Ryan wants to know, can the finding committee be anonymous, or does the violating party have the right to know who makes up the committee? They have the ability to go in front of that committee at the hearing and basically, I don't say confront them, but they have the ability to present evidence and say why the fine shouldn't be imposed. So that committee, you need to identify who those committee members are. So some of these questions are a little bit beyond the scope about amending your documents and in the finding process. I'm happy to answer these offline, but another question is, if there's no finding committee, what can we do? If you don't have that, you still have the ability to enforce your documents. It just may be more by way of the board sends out violation notices and then eventually gets to the attorney. And then depending on if you're a condo or HOA, you may decide to go through mediation for HOAs or pre-suit arbitration for condos. There is a way to enforce it. It's just that the finding is a way that you can do it if you have the system set up properly, that you're not having to involve your attorney necessarily, that you have a process that can help enforce itself, for lack of a better term, without outside expenditures. And then if that doesn't work, then you can go back to the attorney. I'm going to save some of these questions. There's a lot of good questions on finding, but I want to get through the rest just because we're going to try to keep this for an hour on the materials, and then we'll get back to some of these questions. Use restrictions, these are some things just to look at, and I kind of touched on it before regarding the rules and regulations. When I refer to use restrictions, it might be pet rules, property uses, basketball hoops, parking issues. Those are considered to be use restrictions, and you typically have a provision, especially from an HOA standpoint. There's usually its own article in your covenants that talks about certain use restrictions. So you want to take a look at that and say, okay, if I want to amend this, do I need a membership vote, or is that something where an example might be for a condo? It might say that you're allowed to have 2 pets subject to rules promulgated by the board. And then the board promulgates rules that say, of the 2 pets, you're allowed to have up to 50 pounds per pet. And that might be a way where the rules kind of mesh with what your declaration provides. So you want to see that those rules and your declaration are kind of acting in sync with each other, as opposed to your declaration saying you're allowed to have 2 pets, but then the board amending the rules to say, no, you're allowed to have 1. That may be where the rule conflicts with the declaration provision, and that owner can say, no, you can't pass that rule. You would need to have a member vote to change it from 2 pets down to 1 if you want to do that as a rule change, for example. Your use restrictions are largely community specific, but I say check if there's a controlling statute or some type of a federal guideline. That typically comes down to energy efficient devices, whether or not it's a clothesline. And there was a community in St. Augustine that had to go through this probably, 10 years ago, that there's a big lawsuit over clotheslines being an energy efficient device. There is something recently regarding condos and skylights being an energy efficient device. We're still kind of analyzing that. It really comes into play regarding satellite dishes and placement of those, because there are some federal guidelines that you have to allow satellite dishes in a certain respect. But for the most part, any type of use restriction, changes might be community specific, that there might not be a controlling statute on it. You just need to be aware of it. And then again, consider what should be in the declaration versus when to refer to your rules and regulations. Do you have anything else maybe from a use restriction standpoint?
No, I think that pretty much sums it up. Again, you want to make sure your documents are consistent. And, it's funny you mentioned the pet rule issue, because I've seen that specific case where the declaration purports to allow a certain number of pets, and then the rules try to limit it a little bit further. That's where you can run into some problems.
So going into the next one, Jim, why don't you kick us off on rental restrictions and really how it depends on if it's a condo versus an HOA.
Right, and I saw someone asked a question about that as well. So in the condo world, there's a specific statute. And if you want to amend your governing documents to alter the duration of the rental term, specify the number of times the unit owners are entitled to rent their unit, basically many provisions that would regulate rentals of units in the condo world, you need to get them implemented in the way that your governing documents require. So if it requires membership approval, it would still need that certain approval and so forth. And typically we recommend that rental restrictions, if possible, be placed or parked in the declaration, whether it's HOA world or condo world. And we can talk about why we like them there a little bit further in a minute. But in the condo world, that amendment, even if it gets passed by a requisite percentage of the membership as it otherwise requires by the governing documents, it still only applies to unit owners who consent to the amendment and unit owners who acquire title to their units after the effective date of the amendment, which is typically going to be when it's recorded. So there's sort of a statutory grandfathering, if you will, of people who are existing unit owners and who don't vote for that amendment. So in other words, you'd have to, if you implement some rental restrictions in the condo world, you're going to basically have to keep a chart or a list, a database of people who didn't vote for it, so you know who that amendment applies to and who it doesn't. The same is not true for HOA world. There's not a similar statute right now in the HOA world. So presumably, if you get that amendment passed by the requisite percentage of the members, it's going to apply to everyone. And there's actually a specific case in the HOA world acknowledging that. And the reasoning in that case was, well, look, yes, when you buy your property, you take subject to these declaration of covenants and restrictions, and you also have knowledge by virtue of the fact that they're recorded in the public records that they can be amended through a certain process. So if they're amended through that process, then you're going to be subject to that. So you don't have that statute in condo world, or you do have that statute in condo world, you don't have it in HOA world. And we're kind of suggesting that, you know, it's possible that the legislature might eventually adopt a statute in HOA world to similarly kind of grandfather people in, if you will. So if you have the idea to establish some rental limitations or things like that, maybe a minimum duration of rentals, you know, I would say strike while the iron's relatively hot before the legislature might impair your ability to do that in the future.
Right. And so this I think we answered George's question here to go back to a question that was asked earlier, which is, our covenants do not mention rentals in our community. Can we address this in our bylaws, or do we need to address this in our covenants? Typically, we recommend a covenant amendment because it probably goes to the use of the property, which is a general probably provision that you have in your declaration. And the argument is that if you are placing limitations on your ability to rent, that may affect that more general provision that to use it for residential purposes. So to be safe, I would do that as a covenant amendment, and that would be where you would affect, you know, Airbnb rentals, you know, minimum of 6 months. If you're an HOA, like Jim just mentioned, and the reason why we start with the condo side is because there's been some proposed legislation which hasn't gone forward, which is trying to mirror the HOA Act to what the Condo Act is, in terms of that only being applicable once you do amend it to future owners and the owners who vote yes. So if you are an HOA looking to do some of this, now is the time to do it, because we're not sure when they're going to try to bring the HOA Act in line. But it would almost certainly require a change to your declaration, which would require a membership vote. But again, once you do that, it's going to be clothed with the strong presumption of validity. It's very difficult then for an owner challenging it, unless you didn't calculate the number of votes correctly, that an appellate court would overturn that amendment on the actual language of the amendment itself. So going into rental caps, we have this question, and we find this with condos and with townhomes specifically. You know, consider this is more of a practical consideration, grandfathering in current owners, even if you're not required, if you're a townhome association, that's an easier way for it to pass. You have the practical item of almost like having a snapshot of who are the owners at the time that it passed versus who are the new owners, and then establishing that threshold if you have a maximum rental amount. But as long as you can administer it, which is really the second bullet point I have there, I think that it's doable. Consider putting in some type of an exception, maybe where the board, we're in Northeast Florida, especially for people here in Jacksonville. It's a military town. You have people that own in there that may be deployed. We want to have respect and understanding for what that means from our service members, that they may have a legitimate reason that, hey, I plan on living in here and I need to rent this for the time being because I'm going to be deployed. Can there be an exception to this? We've drafted that for some of our communities that has a basis for the board to grant an exception to the rental cap, but it will be based on certain limited circumstances. You want to be specific, enough on those so that you're not then grandfathering everybody or being held to a grandfathering, for one owner but not the other, for example. So you just want to be specific for it. And then, we want to talk about rental approval versus the notification requirement. And this is not only for rentals, but it can also be for new owners. We don't see it as much for newer covenants that has an approval process. That typically is for older documents. But if you do have the ability to approve renters or new owners, new purchasers, be very careful about how you're applying it. There's a couple of things. One is from a discrimination standpoint. There's a lot of grounds where if you deny somebody, even if it was solely for the purpose of, it could be based upon, some associations run credit checks, which we found recently believe that may not be a legitimate reason to even deny a renter, for example. A lot of things can be tied to whether or not it's for a discriminatory purpose, which if you're subject to the FHA as a residential community, that may be where you run into difficulties from a discrimination standpoint. So be very careful if you're enforcing those. And Jim, can you talk about that a little bit more, and then also what you have here on eligibility from the secondary mortgage insurance?
Right. So the general message is, if you choose to implement rental caps or primarily rental tenant approval or occupant approval, it comes with some potential risks with that. So with that power comes some risk. One is, again, if you reject the application of a member of a protected class, whether it's someone who has a disability, or whether it's someone, race or national origin, perhaps gender identity. So be careful in how you do this. And, even if you have a legitimate reason to deny someone, it is possible that that person could become disgruntled and make a claim that they were rejected based on their membership in a protected class. So then that also adds the question of, well, do you have insurance coverage for that? And you really need to look at if you have these kind of approval powers and you're exercising them, you really need to make sure you have a beefy insurance policy that will cover claims of discrimination, because there is a positive trend in the number of Fair Housing Act claims that are being pursued and filed on a yearly basis. So it's an upticking trend. It's a significant risk for you all. In addition, implementing these rental approval, tenant approval, or maximum number of rentals, rental cap provisions can have an effect on the liquidity of lots and units in your community. What I mean by that is it can affect secondary mortgage insurance and mortgage insurance endorsement. So FHA, Fannie Mae, VA, those kind of secondary mortgage insurers will have certain criteria and requirements, and they might say, well, one of our criteria is the association can't have tenant approval authority, or we're not going to endorse that. And what that means is, it's going to be more difficult for people to buy properties in your association. Now, is that a good or a bad thing? That's a matter of your perspective. Some are of the perspective well, we like that, Jim, because then people aren't going to be able to put 3% down or 5% down and buy a home in here and then struggle to pay for their mortgage. We want people to have to put 20% down because we think that those people will be, will have more money to pay the assessments, and might be just, because they have more money, they might just be better members of the community. I'm not saying I subscribe to that. I'm saying that's one perspective that I've seen. Other people are saying, well, look, I want these units to be very marketable. I don't want to affect marketability of units. If I want to sell, I want to be able to sell to anybody or as many people as possible. So, maybe we won't implement those. So just keep in mind that whether you implement them might affect sort of secondary mortgage insurance eligibility.
Okay. So we're going to go through, I know we're running up against everybody's lunchtime, but I want to get through some more of these, and we'll take the questions at the end. So from an election standpoint, this is another key provision in your documents to look at. Condos, pretty easy. You're largely governed by the statute. There's not really much that you can do to change anything from an election standpoint. It's really for HOAs. If you're a homeowner association member, board member, or manager that's on here, the biggest thing that I can say is, regardless of what your past process has been as an association, it is arbitrators, if there's an election challenge, are going to look at what's in your governing documents as to how the election process should have gone. And so we've been recommending for our firm, and we've worked with a number of communities to amend their HOA documents to provide for a process very similar to condos, which is, typically it's a 2-notice process. You send out a first notice of the meeting, at least, usually 60 days in advance, having a call for candidates, and then you have a certain time period in which case you can get your name in, you can submit a candidate information sheet, and then the second notice goes out within a certain window saying, these are the people that applied on time and that are eligible to run for the board. Here's the ballot for them. They're listed in alphabetical order. It's a very kind of regimented process. It's very easy to follow, and it makes it easier for you as a board, so that if somebody gets their name in a day late, there's arbitration cases that have said, nope, it's too late. You don't accept them. There's no judgment call there, and it makes it easier for you as a board to say, hey, this is pretty black and white. We have to abide by this. So it helps you out. It also gets rid of the requirement to have nominations from the floor, which can really kind of throw a wrench into elections, especially because if you have a process for nominating in advance as an association, you don't have to make quorum for your annual meeting if you don't have more candidates and there are vacancies. So if you have 5 people putting their name in for 5 spots for an HOA election that has done away with the nominations from the floor, it doesn't matter if you make quorum, those members are automatically seated at the meeting, versus if you have to take nominations from the floor, that means you have to make quorum. And even if you maybe only had 3 people express an interest for 3 spots and you don't think you're going to get nominations from the floor, it doesn't matter, because you're still required to actually make quorum to open that up before you can actually seat those eligible people that wanted to run for the board. So the problem there is now you have holdover directors and you have to make quorum next year. So we've really been recommending for HOAs is establish some process for nominating yourself in advance. If you're going to have nominating committees, it's okay for HOAs. We don't really recommend it that much because it can be abused where the board appoints a nominating committee, and then guess what happens? The nominating committee then recommends those board members who are up to run again, and it's kind of a circular process where those people stay on the board all the time. You always have the ability to run for the board, even if the nominating committee didn't select you. But with some communities that have that, they may make it more like, here's our nominating committee slate. Here are the people that also happen to get their name in on time. Guess who the members are going to vote for? They're probably going to vote for the nominating committee slate if they don't know the difference between the two members. So look at that if you do want to have nominating committees or not. There's a plus and minus. If you do have one, I like to say more of like a vetting committee where it's more, hey, here's who are the people that have run. Are they eligible? Are they paying their dues? And have they been convicted of a felony? And have they had their civil rights restored? Those are the two ways that you're deemed to be not eligible for the board. Or they might be a search committee to say, hey, we'd like for you to get your name in on time, but not necessarily be the committee that says, this is our slate, and having it treated differently from somebody that gets their name in from the floor, for example. So really look at your documents, allow for nominating in advance, and then consider for both condos and HOAs electronic voting. Right now, we have some communities, I know we have Mary Pat from one of our communities that they went through, it's a large HOA, I think 1,500 members if I remember correctly, and they've gone through the electronic voting process, which now it's going to make it more likely, especially now when you don't want people to actually show up in person, that the more people that consent to electronic voting, the more likely it is when you have, hopefully we never have a pandemic again, right, folks? But it is helpful for these communities that have electronic voting to make it easier for people to vote and not feel like they have to show up if they forgot to mail in their ballot or in advance of the meeting. So electronic voting makes it a lot easier to do that. So look at amending your election provisions. All right, we're going to run through this real quick because we've kind of talked about it as a statute versus your governing documents, what controls, and the answer is, like any good attorney, it depends. It really depends on whether or not the statute mandates certain action or if it defers to your governing documents. You may see in the statute it says, unless otherwise provided in the governing documents, then it's this. Well, in which case then that's going to defer to it. Even for the standpoint of condos, which have, some of you condo owners have probably heard of this, it's a material alteration requirement, where the statute says that unless otherwise provided in the declaration, you have to have 3/4 membership approval before there can be any material alteration of the common elements. So that's where it still defers to your governing documents, but you have to have a specific provision on alterations. And so that's where the statute does defer to the documents. In other instances, the statute may just say, you have to have X number of days notice for a meeting. Then it comes down to whether or not it's a procedural versus a more a substantive. And Jim, do you want to talk about that? Maybe if there's a change and what might control versus where your documents may still control?
Yeah, I'm going to try to make a pretty complicated legal issue, as bite-sized as possible for the purposes of wrapping this up. So essentially, if the legislature adopts a statute, passes a statute, and there's a provision of your governing documents that conflicts with it, and your governing documents were in place before the statute was enacted, then there's a constitutional analysis as to what controls your contract or the legislation. And that's because there's a provision of the Florida Constitution, also the federal Constitution, which prohibits the legislature's impairment of obligations of contracts. So it's a constitutional analysis. And frankly, the courts are still sort of struggling, at least Florida is, with adopting a standard by which they judge the degree to which the legislature may impair an existing contract. And there was some case law suggesting that, well, if it affects a remedy or a procedure, then it's not affecting the substantive right, and therefore that's okay, and the law might control in that instance. Whereas if it's affecting the direct contract obligation, then perhaps the contract would control if it was in place before the legislation. Then there's also some case law discussing whether it affects the remedy or the right itself. So to boil it down, if there's a provision of your governing documents that conflicts with a later enacted statute, there's a constitutional analysis that's involved, and it would ultimately depend on what the court decides. And it's it could be a tough legal issue. So it's not always straightforward.
And so then it kind of rolls into this. If you talk about Kaufman language, and I have this here, that's based upon a 1977 appellate case As condo HOA attorneys, we always mention, is there Kaufman language? And what that means is, do you have language in your governing documents that subjects your governing documents to the controlling statute as amended from time to time? And that's the key provision, and we underline that. And there have been some cases interpreting this. You might not have that exact language. Whether or not it fits as Kaufman language is really an analysis for an attorney to go through. But if you do have that language, then you might track those amendments as they come up, even if it conflicts with something in your documents where the statute is now going to control. It just very much depends on what your document provides. And it's really something to think about when you're amending your documents. We do this especially, well, going back to the collection of assessments part. The language that we've included is if we want to bring it in so that first mortgage holders and third parties are responsible for paying what the statute requires them right now, we'll put that language in. But I like to put in language that says, unless a higher amount is required by law as amended from time to time, or something like that, by the controlling statute, chapter 718 for condos, 720 for HOAs. I like that because now you've kind of put in Kaufman language for that specific issue in a way that should only benefit the association going forward. So that's something to think about. There can be good and bad things. You don't always want to say that it should be amended as amended from time to time because you may not like what the legislature puts forward. There might be something that conflicts with your documents. Maybe it reduces the fine amount, or it does something else that you might not want to have the statute automatically apply. So that's where it's very important to work with your attorney and look at it and say, hey, we recommend putting in language in here, but not here. And you have to go through that analysis. All right, so this is our last kind of section here, and then I'm going to go through the questions that we have. And thank you for staying with us. I know we're running right at about an hour here, but I'll go through this and we'll answer the questions that we have. So practical tips and considerations. I wanted to make sure to include this because you go through this process, right? You're here with us today. Maybe you have some ideas that you go and talk to your board members, your manager, and you put together some proposed changes to your documents. You work with your attorney. We help you draft those and then say, yes, this would be enforceable, this wouldn't, we need to tweak this language. And then all of a sudden you put it out to your membership for a vote. That's really what matters if you have a vote that's required of the membership. And we have some communities that we're working with where we're doing it what's called an amended and restated set of covenants or your documents, where what you're doing is instead of going through and striking through and underlying all of the removals and the additions, which would make it extremely hard to read, you're basically saying, this is an amended and restated. This is a complete restatement of our documents. For the previous text, or for the previous text, please refer to the originally recorded of the previous documents here. And so now you have a clean set of documents. Well, you can see what the pro of that is. It's the cleaner document. You can make wholesale changes. It's easier to refer to in the future. The difficulty is that if you're making a bunch of substantive changes, an owner may not like one thing, and because of that, they may vote no as to the entire document because it's really one vote. And so that's where it's really important to figure out, hey, do we think that we can get all of this passed in one document? Should we change this a little bit to make it a little bit more likely that owners will vote in favor? Because it's really an all or nothing vote if you do an amended and restated declaration. Versus individual amendments that you can do that, and you just want to make sure that they sync up. And so that might be, I was talking to Jim about this before, you may change something that might affect a couple of different articles in your documents, and that can be subject to one amendment, but you don't want to have multiple amendments that if one fails, it might impact the other one. So you have to be careful about how you're structuring those. But that's certainly option two. The problem with it that some owners don't like is that now you have multiple amendments that you're trying to keep track of all these things and figuring out what's going to control. So think about that from a practical standpoint. It kind of leads into the next thing about the vote, which is having town hall meetings. And this again is if you're having membership approval that's required. It's strongly recommended, even if it's not required. It allows members to ask the question. So ideally what you do is you would send it out either by way of an email link or mail it out to the members and say, we're going to have a town hall meeting on this date. We're not voting on it. We want you to review these and come to us with questions so we can help answer them, or anything that we can consider as a board if we might need to tweak anything. I found that those are very helpful because the time when these amendments have failed is when you saddle the membership with a huge amount of changes that the board has worked tirelessly on, and the board has kind of worked through internally, hey, this is great, I think this is really gonna fly, and all of a sudden you've got all these owners that say, I just got this 2 weeks ago, this is the first time I'm able to ask questions, and you're asking me to vote at the same time at night. Owners get upset with that when that happens. And so what we found is if you can do a town hall meeting before you actually have the meeting where the vote is actually gonna take place. And so from there, you might say, wow, we didn't realize that there would be that much opposition to this. and especially if it's a amended and restated document where you're going to want that owner's yes vote, and you don't want them to feel like, well, if I don't like one thing, I'm going to vote no to the entire thing because I don't want that one thing to apply. You might want to tweak some of the language based upon popular response from the membership. So be considerate of that too. Jim, do you have any other practical considerations?
Yeah. So to parrot what Ed said, people kind of are apprehensive to approve something that they feel like they were notified at the last minute of. A lot of this stuff, your membership isn't going to be looking at your documents as much as the board and the people that are, or the committee that are involved with making these changes. And a lot of it's going to be foreign to them. So when you hit them with a 30-page document and try to get their approval in 2 weeks, it might be tough to do that. So these town hall meetings are, they're just practical. They're helpful from a practical standpoint because it gives people a heads up. It gives people an opportunity and a forum to express some of their concerns if they have any. Then you can tighten the documents up based on those concerns and before you send them out for the formal approval. And to get that formal approval, there are a few methods you can employ. One of which I've seen to be successful is, maybe adopt or appointing street captains to literally have someone as the captain of the street, go door to door and try to get people's, signatures on proxies or get support for the amendments, right? And particularly for the person who had to be about 1,000-member community. We've had 1,000-member community approve document changes and declaration amendments that require a substantial level of membership approval. And that door-to-door pounding the pavement, now obviously right now during COVID might not be the right time for that, but there are strategies that you can employ to get those votes that you need. And communication is really key. It avoids people being surprised.
Yeah. All right, so with that being said, I'm going to go, it has our information up here, but I'm going to answer the questions. We have about 17 questions here that we'll try to get through. Before we jump to them again, I know we have a lot of our clients that we work with. We thank you for working with us. We're here, we're all working, and we are happy to help you out with any questions that you have to help you with these documents or anything else that you may have for your community. We will be teaching some more webinars on this. You again can go to our YouTube, our webpage, which is FLCA Legal. We have a YouTube button on the top right there, and you can see some of our videos. We'll be posting this. But reach out to the attorney that you've been working with. We're happy to help you with any questions or helping you through any language for these amendments. That's what we're here for. If you haven't worked with us, please feel free to reach out to us. We'd be happy to send you some more information. And working with us as a firm, we'd be happy to provide that to you. So going into some questions, going back to George, he had said, our covenants do not address HOA board elections yearly or otherwise. According to Florida law, it's not addressed. It falls to yearly elections. Can we change elections to every 2 years through a bylaws change, or we need to add this to our covenants? The statute, I think what you're saying is regarding if you wanted to have 2-year terms and everybody's elected at the same time, that's proper, where there's no requirement to have staggered terms where you have an election each year. You would just need to make sure that that's spelled out in your bylaws as to the terms of the directors, so that syncs up with when your elections are going to be held.
Yeah, but of course, when you make a bylaw change, it still has to be consistent with the document of higher priority.
Yep.
So, you have to look at your articles to make sure that where you're implementing that, it's consistent.
Danny asks, going back to document priority, can an easement granted by the developer be removed by amending the condo documents? Typically, no. It depends, though. There is a provision in the Condo Act that talks about any type of grant or reservation. And if the developer does it in the name of the association prior to turnover, there may be ways to look at that. But by and large, if it was done prior to the recording of the declaration by the developer, it's difficult to get around that. It would be document specific, though, for your community. There are some ways, though, if it's related to like an agreement or a reservation or something that was done by the developer when it controlled in the name of the association, there is a provision in the Condo Act that you can get potentially around that, but we would need to look at that for you. Mary Pat wants to know, will we be sending out the recording? We won't be emailing it, but if you check on our website, we should have it up there in the next day or two that the recording will be made available. Robert wants to know, does the board make the fine enforcement committee review? Okay, yes, so the board makes the fine, the enforcement committee reviews and either validates or waives it. That's correct. That's the way that the process works. Helen wants to know, can a master association finding committee stand in place of a sub-association finding committee where there are no 3 members willing to serve? The problem is that the statute says that the finding committee has to be made up of members of the association that's going to be levying or approving the fine. So you need to have it as members of that of the sub-association need to be willing to serve on that committee if it's a fine that's been levied by that sub-association board.
Yeah, you might want to check and see if your master association has the ability to directly levy the fine against the person.
Right, and just have them go through the process. The next question is $1,000 fine can be sent for collection, or can it be? So why amend to treat like an unpaid assessment? What benefit does it provide to the association? So the statute just says that once it reaches 1,000 for an HOA, really what the statute says is no fine then less than 1,000 can become a lien against the parcel. There's still a lot of interpretation amongst attorneys as to what that means. Is that enough for you to send it to collections, or do you need to have additional language in your governing documents to treat it like an unpaid assessment? For example, I don't know that that language, even if you could send it for collections, that allows you to charge late fees and interest or even attorney's fees. But if you amend it, there's a better argument that you're almost treating it like a special assessment that's been levied to the account. Hasn't been tested, but we prefer to have language in the documents that kind of takes the statutory, I say that the statute opens the door, and then we can walk through it and then place that language in the covenants that treats it like an unpaid assessment once it reaches 1,000 or more. If you don't have that language, it's just subject to risk and argument from an owner saying, well, yeah, it just says that no fine less than 1,000 become a lien, but that doesn't mean you still treat it like an assessment. The statute doesn't give you the authority.
Yeah, so sure, you can collect $1,000, you can get a money judgment for it, but are there assets? Do you want to have to go through all that? It affects the remedy of being able to foreclose on someone's home because of a fine reaches a certain amount. That's the language we're suggesting implementing in the governing documents.
James asked, we're going through the revitalization process. Do homeowners have the option to opt out of the association once they join? No, generally no. If it's a mandatory association, you don't have the ability to opt out. If you go through revitalization, as long as it receives the necessary approval of the members, then it's going to apply to all the members, not just those who vote in favor of it.
Yeah.
Is there a website that summarizes changes made to 718 and 720 for the statutes that apply to HOAs and condos? We will, as a law firm, we provide updates if there's changes each year. There really isn't much of anything from this year from a legislative standpoint. Really the last substantive change was in 2018. If you want to email us, Richard, I'd be happy to just give you a quick response back to it. But we do teach this in our board certification class as well as to some of the new changes. But otherwise, there's not really any one-stop shop. We typically will update you as a law firm if you work with us as to what changes are made and how that would apply for your community. What if condos are in an HOA? I think that might depend. Maybe if it's a condo association within a master association, you still are going to have the rules are going to apply depending on kind of like what Jim mentioned as to who's levying the fine. If it's the condo for a violation of the condo rules or restrictions versus the master fining a condo owner for a violation of the master documents. Typically, if there's a master, most of the enforcement comes from the condo association itself, is what I would find. That would just be document specific, though. We'd have to take a look at that for you more. Lou has a good point. Please address specific techniques to work with owners who can't pay monthly dues due to COVID. Do you draw a line at 90 days? I think one thing some communities have started looking at is when the delinquency started. If it was kind of lining up with, April or onward from really when people were, you see the unemployment numbers, people being laid off or losing their jobs and having financial difficulties, you might establish some type of policy of allowing, maybe it's a way of a payment plan or something, but we've advised against any type of proactive statement to owners saying, hey, we know that this has been tough, we're going to suspend, don't suspend collection of assessments for sure. Some communities have said we're going to suspend late fees. I don't know that I would proactively do it so much as if an owner receives a collection letter and then asks for some type of a plan. I think you could do it on a case-by-case basis, but you don't want to hold yourself to something or make it seem like you're waiving something that you could collect if they go through foreclosure, because you want to have that liability come on the new purchaser. So I think we need to be compassionate. I think we need to be empathetic, but I think we need to do it in a way that, as a reminder that if owners stop paying, all the people that are able to pay are going to subsidize that, because bills have to be paid. Landscapers are still doing their work. You're still paying your management company. You're still paying, everybody else that still has a contract or gets paid by the association. And so that money needs to come from somewhere. So I think there's reasonable ways to work with owners, but I wouldn't be proactive in a way of saying, we're delaying collection of assessments or we're suspending late fees and interest. I would make it more on a case-by-case basis if owners ask for that. Ellen asks, if an owner wants to provide guidelines for renting their home and requests that owners provide the name of the tenant, their mailing address, and the tenant signed agreement to the community rules and regs, could they do that as a rule and reg change, and can the board vote, or would that need to be an amendment? I think really if it's more of a notification thing, I think that would be properly done as a rule. That's not really preventing anybody from renting their unit. It's more of a, we're not stopping you from renting it, but we require this type of notification. If you require the tenant to sign an agreement to abide by the community rules, I wouldn't say that if they don't sign it that they're prevented from renting. I think maybe you could say it could be subject to a fine. That might be difficult to enforce. I think you could try it as a rule, but I wouldn't say that this would require any type of a declaration amendment. What do you think, Jim?
No, probably not. And in terms of getting tenants to sign the community rules and regulations, they're subject to the rules and regulations whether they sign them or not. So I don't know that you need to implement that requirement, but what it might do is just practically require the owner to give the tenant a copy of the rules, and maybe they're more inclined to comply with them from that standpoint. But yeah, bottom line is all you're looking is for some kind of note, some information. You're not regulating the rental or prohibiting it. I think you're probably fine in the rules and regulations there.
Next question is, if you have condos within your HOA, what rules, regulations have precedent? That's going to depend, again, on what rule is being violated. If they're similar, which entity is going to be taking action from an enforcement standpoint. So it's difficult to say. Usually they work in harmony where you don't find them stepping on each other's toes, is what I find. But it would depend on I guess if there's conflicting restrictions, maybe the condo adopted after the fact that might conflict with the master declaration. Typically it's the earlier document that's going to control, but we'd have to take a look at that for the specific violation and what the board is looking to do for the respective association. If you can't get into the declaration, where would be the best place to include rental restrictions? Again, kind of going with Ellen's question, that might be something you can adopt as a rule regarding like a notice requirement. But in terms of the ability to prohibit rentals or to place like a cap or a minimum duration or something, it's just very difficult to have that be enforceable if it's not voted on by the membership. It's probably going to need to be a declaration amendment, because you would argue that that's a change as to think of it to, and Jim, what's the standard again? That kind of the standard is that I can do what I want with my property, right? It's I can do what I want with my property, and so there's a default rule against any type of restrictions in place. So you kind of have an uphill battle, I guess, as an association. So from the standpoint, if you're trying to put it as a rule as opposed to something that's voted on by the membership, the default argument the owner has is, you're trying to keep me from doing something that I should be allowed to do. This is my property, and you have to have a good reason for doing it, or it has to be in line with something that's lawful.
Right. So Florida does like protecting personal property rights. There are generally restrictions on alienation, which rental is one form or leasing is one form of alienation, are generally disfavored under Florida law, but courts will enforce restrictions, reasonable restrictions. So ideally, you want to park them under the hood of the declaration. You have a stronger basis to enforce them there. It's a different standard by which they're judged by courts. And it's basically the burdens on the other side to challenge the basis for that regulation if it's in the declaration. Whereas a rule and regulation is you're kind of on equal footing, and you as the party asserting to enforce that rule has the burden to prove it's reasonable if that's challenged. So you're stronger if you're in the declaration. But if you're an HOA, there might be some support to park some regulations in your rules. It's just you might have a little more risk doing it that way.
So Brent asked, what's the approximate cost of electronic voting? It depends on the size of your community. I think I found that it's no more than maybe, and I know we have people, I don't get involved in the dollar amount, maybe a couple $1,000s at most, but that might be where once you have it set up, then in the future, it's not as expensive to have further meetings to do it that way. And that might be on the very high end too. I might be overstating it, but I don't remember being more than a couple of $1,000s. There's some vendors, if you want to email me, that some that we've worked with, that our communities have liked working with, I'd be happy to provide you with that recommendation, or at least contact information. Let's see. Do town halls need to be noticed only if there's going to be a quorum of the board in attendance? I would recommend, if you have a quorum of the board there, even if they're not making any decisions, just be safe and notice it as a board meeting and just list it as town hall meeting. You're probably going to give more than the 48-hour notice anyways, because you want people to show up and the opportunity, but you should, if you have a quorum of the board there, you should still list it as a board meeting, because arguably if any of those board members start talking about association business, even if they're not making any decisions, it's arguably a meeting, and so it has to be noticed as such. Let's see. Andrea wants to know, is there hierarchy on assessment collection for condos and rec association inside a master association? That again, Andrea, I know you're worked with your community. It's going to depend. A lot of times you try to work in harmony with the two associations where one will take the lead, and maybe you reach an agreement between, we'll take the lead, we'll incur the attorney's fees, but we get paid back first. You know, I think that's the best way to approach it, so you're not necessarily duplicating efforts. If you don't, I have seen instances where two associations that might have two different management companies and two different attorneys almost race to take title, and then now each one has an argument against each other as to who owes each other money. I would try to avoid that and try to practically work it out so that one takes the lead on it, but otherwise you could get into issues of priority and who gets paid what, and if you can try charging the other association back for some of these amounts. Okay, Mary Pat, for her community, she said for around 1,500 members, we are less than $2,000 for the year. We can use it as often as we want during that year. So I hope that answers, and that's for a very large association too. Thanks, Mary Pat. I knew you'd come through and give me that.
On the electronic voting. Yeah.
On the electronic voting, yep. For our CAMs here, we do not have this yet for approval. We will reach out, we will notify our members once we have approval for this, and we can go through the process of making sure that we comply with the state requirements. But we otherwise thank you all for attending. If you'd like to have a copy of this presentation, please email me. My email address is here on the slide. It's eronsman@flcalegal.com, and then our website is FLCA Legal. But if you have anything, if we can help you out with your community, please feel free to reach out to us. And otherwise, everybody stay safe, and we will be in touch with you soon.